Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today is a Lawsplaining the News live stream. I don't know. I'm trying to do some of these legal news segments, trying to test out this restream feature. I'm currently streaming to multiple platforms. YouTube, Stream Me, and Twitch. I added Twitch at the last second just to give people some options to consume the content on their favorite place. And now I've also integrated the Restream chat box, which should show all of your chats on the thing, whatchamacallit, in a little sidebar, and it gets rid of some of the stuff. I think it looks a lot nicer, and hopefully it works. I am noticing that it has a little bit of a delay, so bear with me if I don't get the chats as fast coming on the stream as you're typing them up. It's got the routing software going. It's not perfect, but it's better, I think, what we had. And it should be showing all of the chats from YouTube, Twitch, and Restream, and Stream Me, and I guess Restream too. I think you can chat on there, but it should all be there. So thanks for joining me tonight. We'll go through a couple questions. Don't know if there is super chats. I don't know if those pop through on here or not. I guess it doesn't really matter, does it? I'm going to read through them. The only other thing I don't have, I still don't have the the justice chats coming into the stream in a way that's easy to find, but I'm working on that. Bear with me. Boomer tech is my specialty. So, all right, guys. Here's what we're doing. We're gonna cover some videos, some some news stories. I've got documents from the Southern Poverty Law Center lawsuit. We'll check that out because those guys seem to be a pack of dirtbags, don't they? My mic cuts out at odd times. Did it the last stream too. Well, here, let me... I think I know why. I think if I do this, it'll be a little bit better. So hopefully that helps fix that up. But, yeah, Rekieta News Network intro would be pretty funny. Okay, so we're gonna cover a couple different subjects today. Like I said, I've got the documents for Southern Poverty Law Center, which is a garbage operation. I've got the I've got an order I didn't go through. If you remember, there was this one stripper / porn star. Her name, Stormy Daniels. Yes, maybe you've heard of this lawsuit. Stormy Daniels, represented by powerhouse, superstar, ethics-laden attorney, Michael Avenatti. Probably the biggest credit to attorneys that exists anywhere. If we had to be honest about it, he's got to be the best attorney. And 2018 was a great year for him. Couldn't stop winning. So in that lawsuit, where Stormy Daniels sued Donald Trump for defamation, the case went exactly as planned, and then there was a motion for attorney's fees that Michael Avenatti won handily, I think. We're going to read that document and check into it. And see how that one went. Because it's kind of funny. And I did cover that lawsuit, so I figured I'd go ahead and cover the actual results of the lawsuit, and that'll be good. All right. Where people are asking for Lady Rackets, Where is Lady Rackets? She is upstairs. I don't think she'll be joining us on the stream tonight. I know she is everybody's new favorite part of the channel, but her appearances, of course, will be at her discretion. At her discretion. But first, what better event to open up our conversation with than a police officer acting in a way that we can all agree is appropriate and professional. And it's actually really, really common for this sort of incident to occur. And we're gonna look at it. We're gonna look at it. Some of you may have seen this. I will warn you, there is disturbing footage in this video. There's some language, and there might be some loud noises. And of course, oh yeah, a police officer shoots a dog. And that's on camera, so that will be there. I'm gonna hit the super chats and justice chats first. If you want to interact, you can do the justice chats and super chats. You know, that is there. I just realized something. The one thing I don't know if this chat picks up is like donations and stuff on Stream Me, but again, learning process. But yeah, so if you don't like that, once I start the video, it's 3 minutes long. We'll watch it and talk about it and talk about what happened, because there's more than just the shooting that happens. But this is a common thing. Cops shooting dogs is becoming, I'm not saying it's common in our news feeds, because it's becoming more and more aware. More and more people have cameras. Police shoot dogs to defend themselves from dogs. So we're going to talk about that. Then we'll move on. But first, those chats. So this was actually sent 6 hours ago by Jay. And Jay said, I'll probably be asleep for the stream. So here's a request/reminder for you to talk about your grandfather and the 24-hour news cycle. Let's see. I can talk about it briefly. My grandfather, who I love very much, both I liked all of my grandparents quite a bit, right? My two grandfathers have both passed away. My grandmothers are both still alive. My grandfather, who died first, I was very close to those grandparents because they did a lot of babysitting for me when I was little, and my parents were working. They would pick me up from school and stuff like that. So I had a pretty good relationship with them. But in the later years of his life, and prior to my grandmother's current situation, which is old age is rude. Old age is a rude thing. They started watching CNN, for example, all the time. Never not watching CNN. It was always on the TVs in the house. Crazy amounts of CNN being consumed. And of course, they're like 100 years old. Not really. They were old, but not that old. But they had, all the TVs were like the old CRT TVs. So all of the anchors on CNN still looked like garbage. But yeah, so in watching that, 24-hour news cycle, they became, you could see it. And it was really distinct and pronounced for me because I lived 1,000 miles away at this point. So when I would go visit them once or twice a year, you get the progression, right? Because the last time you saw them, they're vastly different than this time. When you're seeing them 6 to 12 months apart, and watching what happened to them and the questioning that they came about. I want to point out that the news didn't create for them a questioning of events from a critical perspective of what is going on. It had them questioning basic things about history and about the justice of actions that were taken. And I'm not quite sure. I mean, they may have agreed with some people out there based on these things, but it so divorced them from their values. And that's what I want to get to. It's not really the result of where their opinions ended up. Plenty of people share some of the similar opinions that they had. It was how radically their opinions shifted from this exposure. It really showed the propaganda that the effectiveness of the propaganda that the mainstream media has done to an entire generation, actually to several generations. They have set themselves up as bastions of credibility and trustworthiness, and then without critically assessing the storyteller, the stories are all taken as true. And what that can do to someone, rather than just merely changing their minds, right? Because changing minds is one thing, but undermining their own intrinsic value, undermining their own, the trustworthiness of their own memories and the trustworthiness of their own core beliefs is something that is, I think that's something left out of the casualties of the news cycle. They're all about changing minds and educating and changing opinions, but sometimes doing that involves tearing someone away from who they've been for 50 years. And when you do that to someone, it has to be done carefully. It has to be done lovingly, I'll say. And if it's not done in that way, then you've got a real issue with what's going on. So I can't really talk in depth about it right now beyond what I've done, but it was just an amazing and awful thing to see. And to witness them go from confident people to literally fearful people, afraid of impending world wars, afraid that the U.S. Was going to collapse. Like, take Glenn Beck and all of his fears and then put them from a loud, braggadocious radio blowhard into just a normal person and put the fear in there without the bravado. And that's what it was. It was weird and terrifying. I didn't like it. I don't like it. So that's that story, sort of. Someday maybe I'll tell the full story, but it needs like a video that's more prepared than this. All right. So Ink Penification says, a lawyer that's a good man. Are we living in a bizarro land? Oh, if that's about me, I appreciate it. Thank you. Yes, you are. Ink Penification further says, would you survive the legal system in Japan where it is legally guilty or literally guilty until proven innocent? Also, how would you win against Phoenix Wright? Well, I don't know if I would. I have to work within that Japanese legal system. I think that's a horrible way to do things, so I wouldn't like it. Would I survive there? If I had to, sure. How would I win against Phoenix Wright? I would turn off the game. Devastating to him. Rekieta says, today we guess on how long before Nick is banned from Twitch because of ableist speech and problematic opinions. We'll see. We'll see. All right. Okay, guys. Let's delve into this this video. Let me unmute that. All right. So bear with me. Like I said, this is 3 minutes long. Oh, I need some headphones for this. All right, here we go, guys.
Not my dog. No, I don't have to step out there.
Okay, I'm gonna come to you. Your dog gets aggressive. I'm gonna shoot.
Yeah, like she was about to do. Pointing a gun at my house.
Okay, that's why I asked you to step to the road. You see how he's acting right now?
You can ask that neighbor right there. These
you
dogs.
Want to step to the road?
No, I don't want to step to the road. Are you fucking kidding me? Are you fucking kidding me? You're fucking kidding me.
I told you.
I'm gonna contact the sheriff. Thank you. Thank you.
Look at how nice
Get
he is
off
to
my
let the
fucking
dog
property.
Just sit there.
You better get off my goddamn
right
property.
Guys, slowly.
I'm telling you, stay right here.
Will you call my attorney?
Call whoever you need.
I'm not talking to you.
staying
I don't
right here.
have to talk
Sir,
to you.
Stay right here.
And I'm especially not talking to him.
Okay, that'll be fine. Who do you need to talk to?
I'm talking to the sheriff. I'm going to get my attorney involved. And I'm not answering any questions.
Okay. So, I'm going to explain to you.
I'm recording you right now.
That's
Just
fine.
record you shooting that dog.
That's fine. And
in front of me, putting me in danger.
No, didn't. Shot hit the dog. What I aimed at.
Did you see that?
And I told
What
you
if
to
the bullet
step
would
to
have
the
hit a
road,
rock
'cause if
and
you got
ricocheted?
aggressive
I
to
don't.
me, I'd
I'm
shoot.
on my property. I
Okay.
don't have to do what you tell me to.
Okay. That's how your dog got shot.
That's not my dog.
Okay. You just told me it was your dog.
No, I did not.
You
I have it
recorded,
on
you
recording,
said.
bud.
Exactly. I'm
I
not
said you just shot that dog in front of me, putting me in danger.
my dog. Listen to you.
I'm not talking to you, man.
You're talking to me right now. Okay.
I'm not answering any questions.
Didn't ask you anything.
Yeah, wasn't even his dog. Never said it was his dog.
I'm going to file a complaint. What is your name and badge number?
I thought you weren't talking to me.
I'm not answering any questions.
Okay.
I'd like your name and badge number for shooting a gun 2 feet in front of me.
You'll get it.
Thank you.
Will you hang out with him?
Shooting a dog in my yard, on my property, discharging a weapon.
Okay.
I'm not talking to
The
you.
reason we're out here.
No, because this lady pulls a gun right here in the yard, pointing it at me while I'm on my porch. Pulled a gun. I don't know if you even checked to see if she's allowed to be carrying a gun. Does she have a felony?
She has a carry concealed license.
Okay.
We've made contact with her.
3 feet in front of me, shooting a gun.
Listen to me. The reason we're here.
Why don't you go ahead and put the dog out of its misery?
The reason that
Still
we're here
alive.
is
Discharge it
because-
right in front of me.
Because these dogs are
There's
chasing people.
50
trying to
dogs in this neighborhood, man.
Okay.
There's 5 or 6. That dog has never attacked anybody. Ask that neighbor, and that neighbor. These kids running through here, I'm going to have his... you know what? I'm not talking to you. I know
not
how
a large
you guys
dog.
are.
Not a large dog at all.
I'm going to make sure the sheriff, the mayor, my attorney, and everybody knows he just discharged a weapon right in front of me.
Okay, well, he has
On my...
There you go. There we go. So that's the news story here. Is first of all, if you notice what happened there, the officer said, "Come to the street," right? And he said, "No, I'm not talking to you." And then the officer says, "I'm coming to you." Then enters the man's property and shoots a dog, not his dog. Never said it was his dog. Didn't issue an attack command. If you issued an attack command to that dog, I'm pretty sure it would, viciously like snuggle your leg. What are you gonna? What is that dog gonna do to a cop? Like what danger was he in? Oh, here, I don't need these. We can get rid of that. What danger was that officer in at the time? I can't figure it out. But so someone asked me if he has a claim, because he has made some claims here. I'm gonna file a complaint. He can file a complaint, absolutely. He can do a lot of things. But does he have a legal claim, a legal cause of action against the officer? Not really. I mean, maybe there's something. Maybe now actually. Okay, as I think about this, there's kind of a long shot theory, maybe like an intentional infliction of emotional distress. But he's talking about, the cop recklessly discharging the weapon. He could file that claim. He'd probably lose. The officer would have lots of testimony about his expertise with the weapon and would testify that it was close range. It was a carefully aimed shot. It was intentionally done, and the civilian was in no danger. And he'd probably win that case pretty handily. But an intentional infliction of emotional distress claim might have some sort of merit to it if he could prove that the officer shot the dog to cause him distress, which I think is actually, he says, "I'm going to shoot your dog." It's not my dog. But the police officer clearly didn't hear him, still thought it was his dog, and proceeded to shoot it right in front of him. Now, he may have done that to intimidate him. He also drew a taser on the man on his own property. When here's the way this works. That guy doesn't have to say a word to the cops. And he invoked his right to remain silent several times. several times. Police officer kept asking questions. At that point, he could claim he was being detained, especially once the taser was drawn on him and when the firearm was discharged, that he would not feel free to leave. However, he shouldn't have to feel free to leave at all. He asked the officer to stay off his property. This is a bad action by a cop. This is not good. Not good action. Not good choices made by the police officer. And this type of stuff should be looked at with a lot of scrutiny, and the people should be removed. The officer should be removed from duty or penalized in some way. That's just not how you go about doing police work. Not at all. The shooting of dogs needs to be reduced. That's someone's property. People put a lot of time, money, and investment into dogs. That dog, whoever's dog that is, probably has a claim against the officer, especially since the officer had no business doing what he did. I mean, he did not have business coming onto the property. He was not invited on by the property owner. He didn't present a warrant. The owner specifically said no, that he didn't want to talk to the officer, so he has lost his license to be on the property. And I think that whoever's dog that was would have grounds for a pretty big lawsuit, especially if the dog lived because it was taken to a vet. That would be much more expensive than the dog dying, unless it was a really special dog. But either way, holy cats. According to the news, that cop is fired. Good. Terrible behavior. Now, ignore the dog for a second. That cop should be fired. Questioning and pursuing that person in clear violation of his invocation of his Fifth Amendment rights. Cop has two options. When you invoke your Fifth Amendment right to remain silent, they can either leave you alone or they can arrest you. That's it. You don't have to talk to them, especially if they're on your property. Now, if you're somewhere else, you invoke your Fifth Amendment right to remain silent somewhere where you and the cop are in a mutual vicinity, like maybe a strip mall parking lot or something. You may have to leave the area because the cop has an equal right to be there that you do. And so it might be incumbent upon you to invoke your right to not answer any questions and then walk away. And that's fine. When you're on your own property, no, you don't have that duty. You don't have to go back inside your house because you own the property all the way up to the road or all the way up to the sidewalk, wherever it may be, depending on your easement situation. But so his questioning that persists in clear violation of the rights of this cop, or the rights of this guy, and it's really, really kind of disgusting. So, yeah, get him gone. Let's see. James Panzone, ready, go, defense for police officer shooting dog. The defense for the police officer shooting dog is that the police officer has no idea what the level of danger of the dog is. The police officer does not know if the dog has an infection or transmittable disease, and that a bite could be very deadly to the officer. Plus, the distraction of the dog could prevent him from pursuing his police duties. If the homeowner were to make a move that would make the officer unsafe. I mean, the problems with that defense are he had no reason to be where the dog was. The officer had no reason to be there at that point. That's a problem for him, but that's how you would go ahead and defend it. Landon, Rekieta, and James says, "I'll be honest, I hate dogs, but that was sickening." Yes, and I'm sorry to show that, of course. I know a lot of people hold dogs in very high regard. I'm not a big dog person, but I don't like seeing people's pets shot by police. Dusty Carrier, you wouldn't necessarily need to leave, but if you don't attempt to leave, the cop could just say he was just sitting there talking to you, not trying to talk to you while you're being detained. Your Fifth Amendment right to avoid answering questions about incriminating questions, they have to stop asking those questions when you're being detained and you invoke that right. they can just ask you questions on the street, no matter what. Like, just like I could sit and talk to you if we're both in a place where we have an equal amount of right to be. I could sit and talk to you all I want. You could ask me to stop, and I could just, chat it up and try and ask you questions. Once you're under detention from a police officer, then you can invoke that right, and they have to stop. If you don't leave, they can just say, well, they weren't actually detaining you, so the questioning can commence. So that it's not and it's not like a necessary element. It just further cements your invocation of your Fifth Amendment rights, and that's just, honestly, if a cop comes up to you and asks you something, walk away calmly, respectfully. No, thank you. Walk away. I'm invoking my right to remain silent. Walk away. If they stop you, you're detained, and that is the important, crucial step in determining whether or not you're arrested, whether or not you can consent to a search. All of those things really hinge on that detention. So that's why I recommend walking away if it's prudent. Again, calmly, without running, without making a big scene, without giving them any reason to do anything. No, thank you. Turn and walk. At that point, if they stop you, you're under arrest. You're being detained, under arrest for Fourth, Fifth, and Sixth Amendment purposes. Not like you're being arrested and brought to the station, but you are detained or under arrest for those purposes. And that's a good thing to know. That puts you firmly in control of your rights at that point. Okay, next. Orgasmic said, I would have shot that mother lover, and people wonder why I hate cops. Yeah. It's because sometimes, not all, but sometimes cops behave very badly. And when they do, it's really frustrating. It's extra frustrating, actually, because as agents of the state, they should be and are, or no, they should be, not are, they should be, and I hold them to a reason or a higher standard than the average person, because it's the state. They're coming with the guns that they can draw on you, and you cannot draw a gun on a cop. I mean, you draw a gun on a cop, you're dead. They can draw a gun on you all day and not get shot. And if you shot a peace officer who is in the process of his duties, carrying out his duties, you would probably be charged with murder. You would be charged with murder. You'd probably be convicted for murder. So even if you believed you were in the right, shooting a cop is not something you can do. Even if they unlawfully brandish a gun at you, if you know it's a cop who's in uniform especially and who's in the commission of their duties, firing back is extremely limited, almost completely forbidden. They get lower standards. You're right. That was from Mad Chemist Polar. They get lower standards, but we want them to have higher standards. That's what I mean. Our intention is to hold agents of the state to a higher standard. That's what I do. I hold them to a higher standard. But in practice, they get held to a lower standard. And we're going to maybe get into that when we talk about Geiger, Officer Geiger. That's a Dallas female police officer who shot a guy in his own apartment. Okay. Next. Say Brav says outrageous conduct. Yeah, it is absolutely outrageous. If he was fired, that's a good thing. I'm not a fan of like the job lynch mob thing, but that's a person who should not be enforcing law. Should not be enforcing the law. Mr. Grimdark says, Nick, if I super chat you $100, would you drink a bottle of Malort on stream? The entire bottle of Malort? Let's see. I gotta find some. I'd have to look for it. I mean, I don't see why not, but I would have to do like a long enough stream. I don't typically drink that much in a sitting, so it would have to be a long one. I I would drink Malort on stream for sure. But yeah, I don't know if I could even procure a bottle very easily. The entire bottle. We'd have to set that up. I've heard it's pretty bad. Oh. Okay, next clip. This is random, but I see no reason you would lie. Would you explain Posse Comitatus Act in non-lawyer terms, please? I'm no lawyer, so I came away with questions when I read it. Oh gosh, Posse Comitatus is where you cannot... Trying not to mix it up, but Posse Comitatus is where you cannot deploy troops on U.S. soil. Yeah, you can't use federal forces to enforce domestic law in the United States. Tell you what, clip, to do the justice to the to explaining it in like layman's terms, I would need to do research on it and actually like develop a plan for that. But how about I will do a video on Posse Comitatus. If you have Twitter, bother me about it a little bit, and I'll work on doing that. I don't want to sit and talk about it because I would be lying about my expertise. I know the gist of it. It's partly because of the Civil War, where they did deploy, U.S. troops on U.S. soil. We don't want an army we weren't supposed to have a standing army in the United States. It's not how it was founded. And so having an army deployed on U.S. soil is kind of questionable in the first place. We can't quarter soldiers. We have kind of a theme of rules against that. So I don't want to pretend to be an expert, though. I would rather prepare a good video and do that. Next, Andrew Gluck. What if I draw a gun on a cop with a marker? Now, are you saying you would draw a gun on a cop who's holding a marker, or you would draw, like, artistically a gun on a cop with a marker? Both of them would be a bad idea. So there's your answer. There's your answer. All right, well, I don't want to dwell on this dog case here for too long. I've got another one. Briefly, the cop was a canine officer. The police officer who shot the dog was a canine officer. So, shooting the dog. Imagine if the guy had shot the canine officer. That would have been just great. Just wonderful. Where is... Okay, I gotta find it real quick. Sorry, I meant to grab this news story, but I didn't. Here we go. This is from... this is from Hacienda Healthcare. Get that guy. So, this is an uplifting story. An uplifting tale about how Quentin Tarantino was right, I guess. Clip says, that is fair. How about I give you another super chat to remind you instead? Lol. Well, I mean, if you want to do it that way, I'm not going to argue with you, buddy. Not gonna argue with you. So, okay. All right. Woman in vegetative state for years gave birth. Police are investigating. Okay. Oh my goodness. What's up, Medicurist? Medicurist. Yeah. Well, we all know how this can occur. There is another news story out there on when I googled this. it was OBGYN explains how a woman in vegetative state could give birth. Well, I think a lot of those processes happen without cognitive thought. So here we go. What was his name in Kill Bill? Was that Bud? Bud? Okay, so here. This story is so... Oh, it's ridiculous. It's really awful and sad in a lot of ways. But I mean, just like, it's so insane. Buck. It was Buck. That's right. Sorry. A near drowning had left the woman in a persistent vegetative state for nearly a decade. Her universe consisted mostly of a room at a Phoenix Hacienda healthcare facility where she received round-the-clock care. So when she went into labor a few days after Christmas, her caretakers were flummoxed. They're flummoxed. Well, gosh, this is perplexing. Oh, my goodness. Yeah, it was Buck. Bud was Bud the sheriff or whatever, was son number 1 in Kill Bill? I feel like there was a Bud somewhere in there. Or was that just what's his face's character? One of the Bill's brother. Okay. Here we go. From what I've been told, she was moaning. An unidentified source told Phoenix CBS affiliate Hippo, and they didn't know what was wrong with her. None of the staff were aware that she was pregnant until she was pretty much giving birth. Whew. This is a rape victim. Yes, Dr. Fantastic. This is a rape victim. On December 29th, with help from one of the facility's nurses, she didn't even get a doctor to help. Just a nurse. Patient gave birth to a healthy baby boy. The birth and the sexual assault of a vulnerable individual that must have preceded it has cast a harsh glare on conditions at a nonprofit organization that bills itself as a leading provider of healthcare for Phoenix's medically fragile. A Phoenix police spokesman told the Washington Post that the department is investigating, but did not release details about the case. Police report 911 calls were also not available Saturday. Hacienda Healthcare, which has 40 programs that serve more than 2,500 people a year in Arizona, according to its website, did not immediately respond to calls and messages seeking comment. But amid the firestorm that engulfed it in the first week of the new year, the organization has released 2 statements vowing to determine what happened. Well, I think we know how it happened. As an organization, Hacienda Healthcare stands fully committed to getting the truth of what, for us, represents an unprecedented matter. Guys, I don't think it's unprecedented. I mean, the birth might be. Birth might be unprecedented, but I really don't think that this is, it's certainly not common, we would hope, but it's not out of the question. It's certainly not out of the realm of imagination of a major film producer. Of course, maybe Tarantino visited the hospital, we don't know. Let's see. David Leibowitz, spokesman for Hacienda Healthcare, said in a statement released to ABC News. Another statement said Hacienda is already conducting a comprehensive internal review of our processes, protocols, and people to ensure that every single Hacienda resident is as safe and well cared for as possible. Anything less than that is unacceptable to our team, our company's leaders, and the communities we serve. No one has been arrested in connection with the incident, and it's unclear whether police have identified any suspects. Well, here's your list of suspects. Every male who worked for Hacienda 9 months ago. Let me help. That's your list of suspects. Now, start asking them for voluntary contributions of DNA evidence to run against the baby. If they don't give voluntary evidence, you search for work logs, find out who was working that night, and then you get a search warrant. It's not that complicated. You have probable cause to believe that any male working in that particular ward would be a suspect. You can certainly request a warrant at that point. You put them in the same place, the same time. It's unlikely to be a female. Actually, you could just do a blood draw on the baby and run it against a database. Although if they're working in a nursing home, I'm guessing they probably aren't on most of the background checks unless they're a concealed carry holder. If you are a concealed carry holder, let me give you and it's not always DNA evidence for concealed carry holders. Might depend on the state, but at least fingerprints. Let me give you a tip. Don't do this. Also, don't do this for anyone. Not just concealed carry holders. Metacurus Murdochian Archiver says, depends on the coma patient, Sargon of centrist. Yeah, this is kind of an interesting case. Okay, this is actually a very interesting case. I think from a legal standpoint, it's clear that this is rape, right? It's clear that this is rape. This is sexual assault. It is penetration with the genitalia of another person's genitalia without consent of the person. So that fulfills almost any state's definition of sexual assault or rape, however they classify it. However, the interesting thing about it is the purpose of rape law or sexual assault law is to protect the person from the trauma of the assault. And in the case of this person, we might say that they're incapable of experiencing the trauma that is designed to protect. So from a philosophical perspective on what the law's intention is, it's kind of strange. However, under the legal definition, it's pretty clear. You can't do this. And philosophically, it's clear too. You shouldn't do this at all. You're violating someone's personhood. You're violating whatever level of autonomy they may have, because we don't actually know what's going on upstairs in the comatose lady, especially if she was, as alleged, moaning during labor. There is a likely level of experience that's going on there, and we can't simply turn off laws because someone would experience something in a different way. So that's not how the law works. I just thought that was kind of a weird sort of thing, because we do have laws that protect, that are intended to protect on a specific principle, but in effect protect something broader than the principle. And this is a time where that would be the case, I think. It might be interesting to discuss in an academic sense, but of course, someone was obviously victimized. The real interesting thing that I'm not seeing in here is I'm not seeing if there was any family involved. Like, is there a husband that's around there? Is there, if there was a husband, this person's been in a vegetative state for a decade. I think the husband might move on at that point, or could have died or something like that. You know, it's hard to say what happened. They also don't indicate the age of the victim, which I think might be interesting as well. But the other weird thing for me was just like thinking about the fact that these processes do occur with a minimal level of brain activity. They're very extremely natural processes. So that's that. I just thought that was kind of a really weird story. No doubt, if they find this person, they should be charged with sexual assault or whatever it is. However, it would be interesting to defend this person and try and state that the other person couldn't experience, like, if they obviously they'd plead this out. You'd have to, but that they couldn't experience this in the same. Matt Field says, was she married? Artificial insemination. I haven't been able to find that info. Artificial insemination would be possible, but most states would cover unwanted penetration of the genitalia or anus or mouth. Well, those would be with a sexual organ, but the anus and the female genitalia, penetration with a foreign object. So if you're trying to inseminate, even using like the tools that an OBGYN would use, which would be like some sort of tube, and it wouldn't be like a violent sort of thing or like a turkey baster or something crude. But any of that would still constitute some level of sexual assault under most state law. So there you go. It'd be I mean, who's gonna have custody of the baby? That's a real weird question too. Because the dad has rights. Oh no. Keep babies away from dads who rape coma victims. Mithran Emra says, wait, they didn't notice she was pregnant until she gave birth. What kind of medical providers are these? That is a really interesting question. And I don't know the answer, because you would think that there would be some level of whatchamacallit? There would be some level of thank you for the banana. That was nice. There'd be some level of monitoring of the bodily functions, and that should shift. If this was a large woman, it might be hard for them to notice. With her laying down, the organs would probably, they wouldn't push down on the uterus. The gravity pushes down on pushes the organs of the woman push down on the uterus, and the uterus has to push up and forward against that as it grows. If you're laying down, the uterus pushing up wouldn't push forward as much. It would kind of expand in all directions, I would think. And if she's been vegetative for a decade, probably doesn't have a lot of muscle structure, even if she's not obese, but not a lot of muscle structure holding the things in place. So things would kind of just slide out around the uterus, I would guess. I'm not a doctor. If there is a doctor out there, that'd be kind of an interesting thing. But they have that show with like really, really fat women who I didn't know I was pregnant until they're literally giving birth. They like go in, they're like, oh, my stomach hurts. And the doctor's like, you've got a baby hanging out of your lady parts. I'm like, what? Really? Ugh. I don't know. Again, my wife giving birth to 5 children. I don't know how anyone could not know. But that's me. And then Rekieta Law, anime expert, says, this last story kind of hit home because I just finished an anime called Kyosugaiga, a show that would make you appreciate your family, Nick. Well, I don't need a show to appreciate my family. I appreciate them very much. Hammer of Crom, I know a lot about uteri. So there we go. That's that story. What should we do next? But oh yeah, so summary, just for fair use purposes. Summary of this article is, of course, the legal opinion, that is sexual assault. It'd be extremely difficult to defend. Your defense, again, you do a plea deal. Your defense would be, though, that that's not a person, I guess. That would be the argument. That's not a person. That there's, what harm was done, but it's a really weak defense. Not going to work. Best defense is a shaggy defense, and every male who might have slept with this woman should definitely refuse any of the requested DNA tests. Will this end up on Maury, right? Like, who's the father, with the chick just in a coma, a baby sitting on her stomach crying, and then like a bunch of dudes in nursing scrubs standing around, and it's like, which one is it? Oh, good. That honestly, like in full honesty, that would be really interesting. If somehow the dad were to beat the charges, maybe due to some procedural issue with the parents or whatever, or with the police or something, but for the dad to somehow evade conviction and then win the rights to the child as the best caregiver, that'd be insane. What does it come to, guys? Like, gross. All right. Oh, this one. This is Stephanie Clifford versus Donald Trump. Real quick. There is an update in Hambly versus Loader. It's a very short update. It was an order filed today. It was filed on the 3rd, but I think it posted today because I feel like I checked since then because I did a video, but maybe not. Maybe not. This is a quick update in Hambly v. Loader. Hambly being the quartering or unsleeved media, depending on the poison of your choice, which name you prefer to say. Jordan Allen says, what if this is like Immaculate Conception? The Immaculate Conception is often misunderstood. It is not the conception of Jesus. The Immaculate Conception is a conception of Mary. So #Catholic. Here's my fedora. Well, actually, it's the conception of Mary that was immaculate. So that's the Feast of the Immaculate Conception. And not Mary conceiving Jesus, but literally the conception of Mary. So here's the order in Hambly v. Loader. Here we go. On October 19th, 2018. Oh, I scrolled too far. Plaintiff filed an amended complaint in which he alleges that this court has diversity jurisdiction over this matter. Defendant filed an answer on December 21st, 2018 and denies several of plaintiff's jurisdictional allegations. Specifically, defendant states that he is without sufficient information and belief to admit or deny, and therefore denies allegations related to plaintiff's citizenship and the amount in controversy. This leaves the court unable to determine whether the facts upon which diversity jurisdiction is based are disputed. Well, I think they are disputed, but because they answered in such a weird way, they're not clearly disputed. The court is not being hyper-technical. Counsel has a professional obligation to analyze subject matter jurisdiction, and a federal court always has a responsibility to ensure that it has jurisdiction. Now, to me, this is a shot across the bow to both counsel. I can tell you with some confidence that I'm pretty sure Hambly and his lawyer, Bill Richmond, have analyzed subject matter jurisdiction. I would say that with confidence that if they're going to allege $75,000 in controversy, that they've got something to back that up. They know that Prettiest Matt is a citizen of Connecticut, and they know that Hambly is a citizen of Wisconsin. Prettiest Matt was, being a douche. What do you want to pick? In saying that he doesn't know that Hambly is from Wisconsin. Like, oh, he's going to lie about being from Wisconsin? No one's going to lie. You know where I'm from? Wisconsin. What hellhole would you have to be from to lie and choose Wisconsin as your answer? No, I'm not from Burma. I'm from Wisconsin. Like what? That doesn't make any sense. The amount in controversy, like, Prettiest Matt just said nuh-uh, and so now we'll see how that goes. Court must know the details of the underlying jurisdictional allegations because parties cannot confer jurisdiction on the court simply by stipulating that it exists. Let's see. Accordingly, in order for the court to determine whether it has diversity jurisdiction over this matter, the parties are ordered to conduct whatever investigation is necessary and file a joint jurisdictional statement by January 11th, 2019. Now, interestingly, that's 6 days from now. So we'll see. I'll be covering this as it goes, of course. We'll see what happens. But these guys have been talking for a while. So I'm surprised that they haven't actually exchanged some information about this. And maybe they have. And if they have, it could be very interesting if Matt Loader is being hyper resistant to the idea of diversity jurisdiction when the other party puts forth a good faith estimate of damages at exceeding $75,000. So that one's interesting. So properly setting forth each party's citizenship and whether the amount in controversy exceeds $75,000 exclusive of interest and costs. So again, that amount has to be $75,000 and 1 penny, and that has to be the amount disputed between the two parties of damages specifically, not including attorney's fees, which in a case like this, attorney's fees could actually exceed that $75,000 depending on how it plays out. And no costs. So no court filing fees, no investigator fees, no service of process fees. None of those fees can be thrown in there. It has to be $75,000 on the amount in controversy. If agreement cannot be reached on the contents of a joint jurisdictional statement, competing statements must be filed by that date. I'm guessing we're going to see competing statements because I think this is Matt Loader's best shot on this case, is trying to defeat subject matter jurisdiction through the amount in controversy. It seems like his only argument, and so I'll be definitely covering both of those statements. So next. Rekieta Law anime expert says, "A tale of family. Please enjoy your family, Nick." I do very much. So yeah, that's the Hambly versus Loader order. I just saw it today. Wanted to make sure and get it. This is legal news, right? That's legal news in a case that we're covering. So it's brief, but it's there. On the 11th, when they file those documents, or as soon as they pop up on Pacer, sometimes there's a little delay. I will be covering this. That will be, of course, very soon. Or just a week before the Warski Tonka fight. So we'll get to cover that a little bit before fight. So that'll be fun. And I am going, if you guys, some of you guys, I haven't been streaming to stream me as much. You don't watch on YouTube. I am going to the Warski Tonka fight. And that will be, I can't wait. I can't wait to meet some of you guys and hang out, have a drink or two, and watch some flailing in a ring. So, all right, here we go. Next. Oh, a couple chats are there, and then we'll cover this. Stephanie Clifford versus Donald Trump, with the best attorney, Michael Avenatti, representing Stephanie Clifford. All right. Chats. Mithran Emrys says, "Nick, I appreciate my family so much. I bought a house with a room where I can lock myself away from them, Rekieta." Yes. Very true. Very true. Let me flip the script on you. In the last house, I had a sliding door, and then it was actually kind of open all the way through the house. So if I yelled or got really loud, the sound of my voice could travel all the way into the kids' rooms in the middle of the night. Whereas in this house, I have a safe door and then an exterior door from that separating me. And the construction is of a much, much higher quality all around. So it is much more soundproof. Next, Siren Jag says, "Larger women don't know they're pregnant because some medical condition like polycystic ovarian syndrome makes periods happen less often. Then larger women gain less weight because their body already has large fat stores." Well, I think that's a little offensive of you, Siren Jag. You need to think about how your language affects people who are healthy at any and every. Next, Mellow E. "Is there any way to gather information on a particular case? I'm not involved. I would just like to know how it's proceeding. DNC versus Wade lawsuit." Yes, there's a great way to gather information about the DNC versus Wade lawsuit, and that's to follow everything I cover on it, because when there's a document, you will know. DNC versus Wade. DNC versus Wade has been in a holding pattern for a while now. They are doing jurisdictional discovery. That will last until sometime, I believe, in February. They have 90 days from the date of the order, which was issued at the beginning of, was issued in November, I believe. And so they have until February to conduct jurisdictional discovery, and that will include some depositions and stuff. As soon as they file anything, and I check every 2 days or so, you will know. The other way to do it is to create a Pacer account, pacer.gov, and pay for the documents. Or you can let me do it and pay for the documents. It's up to you. But that's how I track the lawsuit, and this channel is a good place to do it. Okay. Next clip says, reminder, Posse Comitatus Act. You probably deserve a better hourly rate, but $30 is the best my budget can sustain for this week to retain your services for one question. Thanks. Buddy, it's very, very much appreciated. Thank you. Okay, Brad Burns. Brad Burns raises an interesting point. He says, if Hambly hit him back, it would just make him look bad and the Matt Princess would be a martyr. And then Hybrid Branch says, if quartering fought back, it would give the assaulter a legal defense. But Loader's butt is grass now. I don't know why you can't rhyme that. That's weird. Those are both interesting points. They're not, they don't completely shut out the issue on either side. If there was a fight though, they could argue that it was mutual or something like that. So that is a possible defense, although it wouldn't be a great one. It would depend heavily on the witnesses who were there and what they saw and what they heard. But all right, let's talk about Stephanie Clifford versus Donald Trump. So I was joking earlier. Stephanie Clifford sued Donald Trump for defamation. She lost. She lost due to Texas's version of an anti-SLAPP motion. I did a video on how Texas law was applied in federal district court in California and how that worked out. But that's what ended up happening. Texas version of anti-SLAPP is a SLAPP lawsuit is a strategic lawsuit against public participation. It means you're trying to silence someone's free speech with a lawsuit. And in jurisdictions that have SLAPP or some sort of equivalent, doing that carries a huge amount of risk. You better know if you're suing someone for words that those words are not justified in any way. Rekieta Law anime expert says, hey, Nick, got to go to bed and leave the stream. Tomorrow's my brother's birthday. Happy birthday to him, buddy. Can't wait for Weeb stream. Love you, buddy. Have a good night. Yeah, man. You too. You too. Have fun with your brother. Siren Jag says, I apologize for nothing. My spirit animal is Joan Rivers. Okay. So here we go. Here we go. So yeah, the risk of a SLAPP lawsuit is typically paying the attorney's fees of the other party, or some other set of damages that could be caused. So here we go. This is 9 pages. I'm going to read through up to the point where it matters. I might skim a couple sections. This matter before the court on defendant Donald J. Trump's motion for attorney's fees and monetary sanctions, filed October 29, 2018. Stephanie Clifford filed opposition to defendant's motion on November 5th. Defendant filed a reply on November 12th. The court held argument on this matter on December 3rd. For the following reasons, the court grants in part and denies in part defendant's motion. So Trump wins a little, loses a little. Court's prior order contains a full summary of the factual and procedural history of this case. On October 15th, the court granted defendant's special motion without leave to amend or to the complaint. The court concluded that Mr. Trump's tweet was non-actionable rhetorical hyperbole and therefore was a protected opinion. The court also granted defendants attorney's fees under the Texas Citizens Participation Act, the law that governed the special motion. On December 3rd, this court held argument on the instant motion. The court subsequently submitted this matter. All right. Attorney's fees. Here's the legal standards here. As the prevailing party on a TCPA anti-SLAPP motion, defendant is entitled to attorney's fees and costs. The TCPA provides in pertinent part that when a court grants an anti-SLAPP motion, the court, quote, shall award to the moving party. So there's nothing, if that's the motion and they win on that motion, they shall award it. There you go. That's the risk of these types of lawsuits in jurisdictions with strong SLAPP protections. Court costs, reasonable attorney's fees, and other expenses incurred in defending against the legal action as justice and equity may require. And 2, sanctions against the party who brought the legal action as the court determines sufficient to deter the party who brought the legal action from bringing similar actions described in this chapter. Language of the TCPA is mandatory, not permissive on the question of attorney's fees. TCPA requires an reward of reasonable attorney's fees to the successful movement. Sullivan versus Abraham. A reasonable attorney's fee, and let me give you the context of the requested fees. So defendant Donald Trump, or no, plaintiff Donald Trump, no, defendant Donald Trump, yeah, sorry. Defendant Donald Trump moves for $389,403.11 in attorney's fees. So there you go. That's what we're talking about here. That's the reasonable attorney's fees that were requested from a defamation case that was dismissed prior to discovery. Mellow E donated and says, thoughts on MasterCard, Visa, forcing companies like PayPal, Patreon, possibly deplatforming individual over reasons. Please keep track of and inform me on DNC versus Wade lawsuit. Mellow E, follow me on Twitter or subscribe to me on YouTube, and you will get all of the updates. Click the notification bell and all that stuff. I announce all the videos I'm going to do and their subjects, especially if it's diversity in comics related or like one of the major lawsuits that I'm following. If it's related to that, I will post about it on Twitter, usually a couple times per day. And then you'll see them come out when I post the videos as well. One thing I'm gonna try and start doing on the big cases is when I do a live stream, to also do a follow-up video that's a summary, like I just did recently with the quartering. That's more focused because not everybody likes watching a 2 to 3 hour live stream. Okay, a reasonable attorney's fee is one that is not excessive or extreme, but rather moderate or fair. That determination rests within the court's sound discretion, but that discretion under the TCPA does not also specifically include considerations of justice and equality. To calculate a reasonable attorney's fees award, Texas courts generally apply the lodestar method, the same standard used by federal courts. Under the lodestar multiplier method, the court first calculates the lodestar by multiplying the reasonable hours expended by a reasonable hourly rate. The court may then enhance the lodestar with a multiplier if necessary to arrive at a reasonable fee. The court excludes from the lodestar amount hours that are not reasonably expended because they are excessive, redundant, or otherwise unnecessary. Standard for award of sanctions. Defendant also seeks sanctions against plaintiff pursuant to the TCPA. In addition to granting attorney's fees and costs to a prevailing party on an anti-SLAPP motion, TCPA provides for sanctions against the party who brought the legal action as the court determines sufficient to deter the party who brought the legal action from bringing similar actions described in this chapter. Although the TCPA does not set out how sanctions are to be calculated, Texas courts have determined that, quote, to comply with the constitutional guarantee of due process, there must be a direct relationship between the offensive conduct and the sanction imposed, and the sanction must be just and not excessive. When adjudicating a request for sanctions under the TCPA, Texas courts often look to Texas Chapter 10 sanctions for guidance. Oh my goodness. Excuse me for the yawning. Chapter 10 authorizes trial courts to impose sanctions against litigants for signing frivolous pleadings and motions. In assessing defendants' requests for sanctions, this court also looks to the interpretation of Rule 11 of Federal Rules of Civil. The court begins by reviewing defendants' requests for attorney's fees and costs, then addressing defendants' requests for sanctions against the plaintiff. Here we go. Oh, I didn't answer Mellow E. Thoughts on Visa and MasterCard forcing companies like PayPal and Patreon to deplatform individuals? I think that the banking system is being exposed, especially the electronic banking system is being exposed as a cartel. There's an independent journalist who's been covering this a lot, Nick Monroe. I'm going to ask him to do an interview on this soon. I would like to also get an expert in financial transactions on the show. I'm just not exactly sure who would be good to talk to there, but I don't think people on your average day consider just how much power those companies have. So it is something that's on my radar, and I'll be covering more and more. All right. Court first determines whether defendant can recover fees for the entirety of this litigation or whether defendant can recover fees only for the special motion, the resulting motion for fees. Defendant seeks $389,403.11 in attorney's fees and costs, accounting for 580.75 hours of attorney time. We have a calculator here. We've got 389,403.1 divided by, see what this hourly rate is. 80 point. Hourly rate of $670.50 an hour. Actually, not unreasonable at all. Not unreasonable at all, considering the customer, Donald Trump, hiring top shelf law firms with massive staff support and strong track records. $670 an hour in legal fees would be absolutely reasonable. It'd be very hard to argue otherwise, given the people in this case. And who knows what Avenetti's fee is, but I'm sure it's north of $500 an hour. Defendant divides his requests into 4 distinct categories of fees. 1, initial strategy. 2, motion to transfer. 3, motion to strike. And 4, motion for fees. Plaintiff insists that defendant can only recover for the latter 2 categories because the former 2 categories did not involve defending against plaintiff's legal action for defamation. TCPA requires an award of fees incurred in defending against the legal action. Although the terms defending and legal action are not defined anywhere in the statute, there is little dispute that the TCPA does not entitle a prevailing party to recover fees for expenses incurred in litigating causes of action that are unconnected to a defamation claim or a motion to strike. For example, in a situation where a plaintiff files a complaint bringing defamation claim based on one set of facts and a claim for breach of contract based on an independent set of facts, defendant who prevails on a motion to strike the defamation claim can only recover attorney's fees for the defamation, not for the breach of contract. That makes sense. Other situations may be more complicated than this example. In the instant case, plaintiff only brought a single defamation cause of action. However, the parties briefed and began to litigate a procedural motion to transfer venue prior to this court adjudicating the substance of defendant's special motion. TCPA does not provide guidance as to whether the terms defending and legal action encompass only litigation connected to a motion to strike or all of the motions required in the process of litigating a defamation cause of action. I would say the second. I would say the second one. I wouldn't say the first. It should be all of the process of litigating defamation, because if venue is improper, like they're motioning for change of venue, if venue is improper, that's part of your defense strategy, is challenging venue. The audio is still going out randomly. That's weird. The best thing to do is to try and adjust this on the fly. Let's drop that. Hold on, almost there. Changing a couple things on the fly. Nothing could go wrong with this. All right. Hopefully that solves the issue. Oh, the audio's been good? Well, it's your fault then. I'm just kidding. I don't know. This is a new mic setup and I'm still tweaking it, so I do appreciate the feedback. Maybe in this case it is yours. Who knows? Okay. Yeah, I would say the venue change is definitely part of the defense, because that's part of your legal strategy for defense. Okay. Existing case law favors defendant's position. In American Heritage Capital versus Gonzalez, a Texas Court of Appeals held that the defendant was entitled to costs and fees connected to an exchange of emails with the plaintiff prior to the plaintiff formally joining the defendant on a defamation claim. The court concluded that to defend means to deny, contest, or oppose any allegation or claim. An allegation or claim. In order to properly defend, a lawyer must adequately prepare by investigation, research, and drafting of pleadings. If a lawsuit is anticipated and, as in this case, comes to fruition, it is both reasonable and necessary to prepare a defense in advance. In the instant case, much like American Heritage Capital, there's only one cause of action at issue in the litigation: plaintiff's defamation claim against defendant. As a result, defendant's preparatory work in this litigation was connected to the same subject matter adjudicated in the special motion. Although defendant files a motion to transfer the case or, in the alternative, to dismiss or stay the case, This motion was connected to defending against the defamation claim. The motion to transfer sought to place defendant in a more advantageous position to be able to defend the defamation claim and the other lawsuits against him in a single forum. The motion to transfer constituted part of defendant's strategy to oppose the defamation action filed by plaintiff. The court thus concludes that defendant is entitled to the attorney's fees and costs connected to the entire course of this litigation, including strategy, motion to transfer, motion to strike, motion for fees. There we go. Yeah, I'm not going to... They argue, but the court has said what they want. I'm going to skip that. That's a lot of words. A lot of words. Is the defendant's request reasonable? Reasonable. The picture stuttering's a problem. Oh, the picture stuttering is my fault. I apologize. I'm going to fix it right now. I forgot to stop my backup. My backup soaks up way too many resources. Should be fixed now, hopefully. Okay. Having concluded that Mr. Trump is entitled to all 4 sets of attorney's fees and costs that he seeks, court next addresses whether defendant's request is reasonable under the lodestar method. This involves answering 2 related questions. First, are the requested hourly rates per attorney reasonable? Second, are the hours expended per task by attorney reasonable? Court addresses those questions in turn. Defendant claims the following rates for the attorneys that worked on this matter. Attorney Charles Harder, Chuck Harder, guys, charges $841.64 per hour. Attorney Ryan Stonerock. No wonder Harder Stonerock is the the manliest law firm name I've encountered this week. Charges $756.49 an hour. Attorney Dylan A. Esper charges $611.99 per hour. Attorney Stephen H. Frackman charges $586.50 per hour. And attorney Ted S. Gwen, I think is how you pronounce that, charges $307 per hour. Federal courts determine a reasonable hourly rate based on the experience, skill, and reputation of the attorneys requesting fees. Federal courts look to the rate prevailing in the community for similar work performed by attorneys of comparable skill, experience, and reputation. Similarly, in analyzing the reasonableness of the rates charged under TCPA, Texas courts generally consider several factors, including time and labor required, novelty and difficulty of the questions involved, and the skill required to perform the legal service properly. 2, the likelihood that the acceptance of the particular employment will preclude other employment by the lawyer. 3, the fee customarily charged in locality for similar legal services. 4, the amount involved in the results obtained. 5, time limitations imposed by the client or by the circumstances. 6, the nature and length of the professional relationship with the client. 7, experience, reputation, and ability of the lawyer or lawyers performing the services. And 8, whether the fee is fixed or contingent on results obtained or uncertainty of collection before the legal services have been rendered. In reviewing the rates charged by defendant attorneys, the courts agrees with defendant that his attorneys are incredibly qualified and that the law firm Harder LLP has specific expertise in the fields of media and defamation law. Court also is mindful of the fact that the instant litigation is unique in its nature and scope and involves a defamation claim against the sitting president of the United States. Based on a tweet issued by the president from his personal Twitter account, the president has used his Twitter account extensively, both during his campaign and afterwards. Litigation before this court therefore impacts what the president may or may not say in a public forum. Based on the unique nature of this litigation and the court's familiarity with the fees charged in this jurisdiction, court concludes that defendants' rates requests are reasonable. In similar First Amendment anti-SLAPP litigation involving highly qualified attorneys, a court in the Northern District of California held that experienced partners were entitled to between $880 and $995 per hour. Senior associates were entitled to between $450 and $535 per hour, and junior associates were entitled to $355 per hour. Hours spent. A court may award attorneys' fees only for the number of hours it concludes were reasonably expended on the litigation. So there you go. I mean, that's those are expensive attorneys for sure. However, they are reasonable under the standard. So that's nice. That's nice. The court next reviews the number of hours a defendant claims that his attorney spent on each task. What case is this? This is the case of Stormy Daniels versus Donald Trump. Each task to determine if the hours requested are reasonable. When faced with a massive fee application, the district court has the authority to make across-the-board percentage cuts, either in the number of hours claimed or in the final lodestar figure, as a practical means of trimming the fat from a fee application. Having reviewed the billing records submitted by defendant, court reduces the total amount in attorney's fees and costs that defendant claims by 25%. The hours requested by defendant are excessive for two reasons that parallel the Wynn case. First, defendant could have researched and briefed this case with less involvement from partners and greater use of highly qualified associates. To litigate plaintiff's defamation claim, defendant used 2 partners and 1 senior associate in addition to 2 junior associates. I don't think the judge is properly assessing legally, properly assessing it, but properly assessing the fact that the president of the United States likely demanded having the partners on the case in all aspects of it. That's, Trump's a CEO, billionaire CEO plus president of the United States. He's gonna demand the best person, and they probably knew that this was coming, and they're gonna mitigate it that way. 2 partners and 1 senior associate in addition to 2 junior associates. Defendant could have streamlined litigation by distributing more work to the junior associates. Second, the descriptions of the work performed suggest that the hours spent on tasks by defendant's attorney were excessive. For example, defendant's attorney spent significant time conducting legal research for both the motion to transfer and the motion to strike. The court agrees with defendant that preparing a motion to transfer requires a significant amount of factual research. That being said, with Harder LLP's vast experience in the area of defamation law and federal court litigation, billing substantial hours for legal research connected to a motion to strike or motion to transfer is not reasonable. Moreover, in briefing the special motion, defendant submitted significant extraneous evidence, including a detailed list of plaintiff's movie history and filmography, which was unnecessary to this court's decision making. You imagine the judge reading through the filmography? Oh boy. Oh wow. That's probably good. Oh. Okay. I think my chat bot may have stopped. I wonder if I can refresh that. I don't know. We'll see. Okay. Sorry. I'm still picturing the judge or the clerk just reading through just going ahead and reading through Stormy Daniels' title list. Mellow E asks, has there ever been a case where your morals conflicted with your duty as a lawyer? If I was representing a child molester and knew he was guilty, I would stick around as his lawyer and make sure he was convicted. Well, don't do that. If you do that, then you would be disbarred. And that would be very bad for you. Very bad for you. Yes, there have been cases which any criminal defense case does conflict with my morals, because I typically, I shouldn't say any, most, because I just defended a case for example, where someone was accused of violating a harassment restraining order by posting a Google review, and my morals suggest that a Google review does not merit 3 to 5 years in prison, and so defending that person on the grounds of free speech didn't conflict with my morals at all, even though he was charged with a felony offense. But when I defend a theft or something like that, that conflicts with my morals. DUI, which I try not to do DUI defense at all. But I talk very candidly with my clients about what I think their legal strategy is, what it should be, and I'm very open about my morals and convictions on the subject, and I provide them a competent defense. If they don't like my defense, I encourage them to fire me. So that's how I can answer that question. Ultimately, defendants' counsel did not need to spend as much time as they did conducting legal research, and compiling factual exhibits that would not properly be before this court. So, I wonder how much harder LLP was researching the films. As the Wynn court concluded, given the sophistication of counsel and their substantial billing rates, this case should have been litigated much more efficiently without sacrificing quality. Court reduces the total amount of attorney's fees and costs claimed by the defendant by 25%. Defendant is entitled to attorney's fees and costs of $292,052.33. $300,000. $300,000. That is fantastic. Fantastic. Couldn't have happened to a better attorney. Defendant seeks sanctions. I don't think they got sanctions. While recognizing that some Texas courts have doubled attorneys' fees to deter frivolous slap litigation, the court declines to impose significant additional sanctions here. So there you go. That would have been brutal, doubling the attorney's fees because of sanctions. So the court does order sanctions of $1,000 because the TCPA requires the court to impose sanctions against plaintiff to deter the behavior. So an extra $1,000 is granted. A pittance. Well, there you go, guys. That's Stormy Daniels. This did happen last month, but I didn't cover it all the way. But I did find it very funny. I found it very funny because Michael Avenatti allegedly may have conducted this case without Stormy Daniels' consent. And if that's the case, she needs to talk to a malpractice attorney. And Stormy, with Avenatti's winning rate right now, a malpractice attorney is going to go very well for you. Also, last I checked, she was unaware of where her GoFundMe money went, and Michael Avenatti seems to have just pillaged it. But you know, good times. Good times. All right, next. So this is a PJ Media exclusive. Won't cover the whole thing. I think this one merits its own video. So I'm gonna touch on it tonight, and then this one should have its own video, which I'll do. Maybe its own live stream, and maybe its own summary. Because I think we need to dump on the SPLC as much as possible. So in December 2018, a Baltimore lawyer filed a devastating lawsuit against the Southern Poverty Law Center. I don't think it's a devastating lawsuit yet. It could be. And 2 of its employees. SPLC targeted Glenn Keith Allen over his former ties to the National Alliance, a white nationalist group. In doing so, the liberal group allegedly violated laws and legal codes of conduct by receiving and then paying for stolen documents in violation of confidentiality agreements. The group went after Allen with the intent of getting him fired by the city of Baltimore and permanently destroying his future prospects. Allen's suit claims that SPLC should have its 501c3 tax-exempt status revoked. Absolutely it should. That it owes him restitution for racketeering. And that it should pay $6.5 million in damages. It also references Allen's pro bono work on behalf of African Americans and his mentorship of an African American teen, powerfully rebutting claims that he is a racist. Allen told PJ Media he now regrets his NA support, and an African American friend of his laughed at the idea of this lawyer being branded as a racist. You should check the Southern Poverty Call Center on StreamMe. Perhaps most importantly, the suit attacks the liberal group for undermining America's tradition of free expression. An August 2016 interview with the Washington Post cited in the lawsuit, SPLC Intelligence Project Director Heidi Barrich, a defendant in the case, claimed to have watched Allen, quote, like a hawk because he had, quote, the worst ideas ever created. This East Europe communist thought crime surveillance mentality is antithetical to fundamental American cultural and constitutional principles protecting freedom of expression and association, Allen wrote in the suit, which can be found on his website. His lawsuit uses concrete claims of law-breaking and defamation to expose the SPLC's Orwellian strategy of branding its opponents' hate groups and orchestrating campaigns against them. I mean, I guess that remains to be seen. I do have the documents. Where are we? Where is this? Hold on. Let me see if I can pull up the documents here. There we go. There we go. What? Why is that there? Oh, I know why. 1 second. Sorry. My brain stopped working there. Here we go. Oh, wait, it's there now. Oh, I looked at the wrong screen. I was watching the delayed video. I apologize. Okay. Let's take a brief glimpse. This is 85 pages. I'm not going to go through all of this. This is 85 pages. But let's read the introduction. They said I want to do a full video on this, and I have not read through the whole thing yet, so I don't want to sit and do that, right now. That seems a little crazy. Plus, I don't think anybody wants to sit through me stumbling through 85 pages on this stream, especially an hour and a half in. All right, introduction. Providence. It's kind of like a philosophical point as the introduction. Providence has endowed humanity with the ability to grow and change. Indeed, we have a moral obligation to grow and change as we learn new aspects of reality. At the pinnacle of the means by which we grow and change should be robust dialogue, open debate, an aversion to taboos, and genuine conversation. This is the theory of our remarkable American traditions of free expression as embodied, among other ways, in the First Amendment. Well, I apologize that I don't look good on stream, me. Sorry. But there are also other approaches to inevitable human discord. One is to draw lines of political or cultural orthodoxy, develop massive surveillance networks and extensive dossiers, and severely punish perceived transgressors who cross those lines, seem to cross them, or even seem to think about crossing them. Barrich, Podak, and the SPLC defendants in this case have chosen this latter approach, motivated by lucrative fundraising aims and employing fundraising techniques decried across the political spectrum as deceptive. The SPLC's avowed goal, under the leadership of Barrich, Podak, and others, is to destroy, through public shaming, loss of employment, loss of reputation, and other severe harms, groups and persons the SPLC broadly defines as its political enemies. Glenn Allen, plaintiff in this case, is one of Barrich's, Podak's, and SPLC's victims. Cause of free expression itself is another, for the SPLC has become one of the most effective forces in the country for stifling honest and robust debate on controversial issues. Barrich, Podak, and the SPLC are entitled to espouse their outlook forcefully. They are not entitled, however, to the following actions, all alleged and supported in this complaint: to receive, pay for, and use stolen documents, including confidential documents and documents protected by attorney-client privilege, to tortiously interfere with Allen's prospective advantage in employment, to defame him by publishing false statements that he was infiltrating the city of Baltimore's law department, or to masquerade as a 501c3 public interest law firm dedicated to a tax-exempt educational mission, when in reality the SPLC fails the basic requirements for this favored status because of its illegal actions, including numerous instances of mail and wire fraud, multiple violations of canons of professional ethics, including improper disclosure of confidential and privileged documents, and failure to train its non-lawyer employees. orchestration of violations of the constitutional rights of the organizations and individuals it targets, and sensationalist supermarket tabloid-style one-sided depictions of its victims. The reality is that Barrich Podek and the SPLC have perfected what scholar Laird Wilcox, speaking of the SPLC, called ritual defamation. Quote, a way of harming and isolating people by denying their humanity and trying to convert them into something that deserves to be hated and eliminated. They accuse others of this, but utilize their enormous resources to practice it on a mass scale themselves. What's wrong with Stream Me? Is it Stream Me server is the issue? Oh, yeah. Yeah, it seems to be Stream Me seems to be having problems. In a moment of candor, Defendant Podek, the editor-in-chief of the SPLC's intelligence report, boasted, "We see this political struggle, right? I mean, we're not trying to change anybody's mind. We're trying to wreck the groups, and we are very clear in our head. We are trying to destroy them." Well, that's unfortunate. See also paragraphs 20 and 35 of this complaint. Barrich has similarly boasted that the SPLC has been, quote, watching Allen like a hawk, because according to Barrich and the SPLC, he, quote, has the worst ideas ever. So here is the essence. Barrich Podek and the SPLC conducted lengthy and close surveillance on, plotted to destroy, and then did destroy Glenn Allen, who is performing ethically and competently as an attorney for his adopted city of Baltimore. Because Barrich Podek and the SPLC did not like what they thought was going on inside of Allen's head. The defendant's destruction of Allen was highly effective, causing his termination as an attorney for the city of Baltimore and ravaging the reputation as an attorney he had achieved over decades by performing ethical and competent work, including substantial pro bono work for African Americans and others. For the reasons set forth below, accordingly, Allen requests legal redress. There you go. There you go. I'm not going to read through all of this right now. A profound opening statement does not mean much about the legal merits of the case. However, SPLC is a giant, steaming heap of garbage. Absolute trash. They do not deserve to be listened to. They are terrible, terrible people. And if you are out there citing SPLC's determination that someone is a hate group, don't. Even if that is a legitimate hate group and you're citing it reasonably, don't do it. Don't do it because they have politicized what is supposed to be non-political, and they do it with the express intent of damaging people. And they shouldn't do that. They shouldn't do that. Let's see. Matt Field says, stream me, guys. Put it on audio only. Fixes lag. Well, there you go. There you go. And a couple people are wondering, they didn't know that I stream on Stream Me. That's because I've only done like one stream on Stream Me, but I'm changing that. I'm, working, trying out this restream feature where I can stream all of the shows to both of them. I promised to do that before and I have failed at it. So now we're working on that. And that's part of my 2019 resolutions or whatever, is to keep doing it. But yeah, this lawsuit is interesting. Like I said, I want to devote a full video, maybe a full live stream to it, to going through all of the documents, analyzing the claims, one at a time. So I've got one more video thing to cover. Let's get that pulled up. Yeah, man, the SPLC sucks. Let's do... Did I watch it? Oh, also, yeah, the Jameski. I don't know if you guys have seen this Jameski issue. Excuse me. He's a YouTuber, and Collab DRM has given him 5 copyright strikes on the same video, or 5 copyright claims on the same video. And he is risking getting a strike, which would prevent his streaming. I'm going to cover that as well in a separate video, probably. The answer to that, guys, just contest the strike. He seems to misunderstand how DMCA works. Contest the strike. He thinks that if he keeps contesting the strike, that they will file a lawsuit. And whether they file a lawsuit or not is irrespective of DMCA. You should contest a strike if you use the video legitimately, which I think you probably did. So if you guys know about that, I'll probably do a short video on it, just like 10 to 15 minutes talking about it. But let's see. I can't find it in my history. I must have watched it like in Discord or something. Here we go. Here we go. So, credit of this video goes to Legal Eagle because it's his video. Whatever. Theater mode. Make that a little bigger. Oh, here we go. Okay. Oh, we're not going to do the ad for Dashlane. Well, let's skip it. And we probably won't watch all of the video because I don't want a copyright strike from Legal Eagle. But here's what's going on. Mithrin Emrys says SPLC never had the plot and the ACLU lost the plot long ago. They have actually become what they purport to fight against. Yes. Terrible. Terrible, terrible people. Terrible organizations. When am I going to hit that dab for you? I can't do it in Minnesota. Can't do it in Minnesota until it's legal. So then I guess, I don't know. Here we go. Let's see what he's got to say. Oh, whoops. I've got it muted. Boomer.
The moonwalk would be like the equivalent of granting ownership over an individual word or musical note. All of these things are building blocks to a complete book, or a full song, or a fully choreographed dance.
Wow, his analysis is so good, it's like it comes from a real lawyer. Hey, Legal Eagles, it's time to litigate a case that is near and dear.
Let me just comment on this. Look at the smug, look at that smug pause. Oh, gosh, that's the smug pause. Oh, it perfectly encompasses Legal Eagle's channel for me. Look at that flipping pause. Gosh, I hate it. I hate it, I hate it, I hate it. Okay, so here's the deal with Legal Eagle. This is what bothers me. Look at how this looks exactly like you would expect an attorney's stream to look, or an attorney's videos. He's got his law books in the back. He's got his stupid face. He's wearing a suit. He's got a tie clip and a pocket square. Who is this? Who is this? Show up to court in cut-off jeans and a wife beater, and then call the judge your wife. That's what you're supposed to do in court. That's how you gotta win. Mithrin Emmer says, and you gotta play his vid at least through where he talks about appearing before the Ninth Circuit Court of Appeals. You know, one level below the Supreme Court. He actually made patent law, you know. But no, I just, it's so predictable and polished, and I hate everything about that. It's probably a good thing, but you know, I don't, you know, come on, buddy. Stop being the thing that everybody expects lawyers to be, because nobody likes lawyers. Be the thing that you don't expect lawyers to be. Siren Jag says, Clay's here? Didn't his liver get left behind in Platoon? I think his liver got left behind in Left Behind. The rest of Clay was raptured. The liver took the fall for all of his body. Okay. So here we go. Let's listen. Oh, so he's accusing another YouTuber of plagiarizing his content. Now, I have been told through the rumor mill that YouTuber has done a mea culpa and taken some responsibility for this. I don't know if that's true or not, but this whole thing rubbed me the wrong way.
Dear to my heart, the case of the game theorist, aka MatPat, versus me. Here is the background. On December 22nd, I released a video detailing my analysis of the Fortnite dance controversy. Basically, the makers of Fortnite are being sued by various artists who are claiming that the game developers stole their dance moves and put them into the game Fortnite. I've done a ton of copyright work in my career. I've actually made copyright law in the Ninth Circuit, which is just one step down from the United States Supreme Court.
There you go, Mithrin. There you go. Comes out of the gate with it. Comes out of the gate with it.
Copyright law is one of my favorite things. Every time Leonard French says that he's your favorite copyright lawyer, I die a little bit inside. So when my friends were asking me whether Carlton from The Fresh Prince of Bel-Air could actually state a claim against the makers of Fortnite for stealing the Carlton dance, I researched the Copyright Act and all of the relevant case law.
Dumping on French. Rude. Rude. You don't bill yourself as a copyright attorney in your videos, usually. So you can die inside. Yeah. This is exactly what I was... Okay. Legal Eagle has pinned this response. I don't know if you guys can see this. Let me... blow up these words. Okay, I haven't read this. I'm going to read this live. We're doing it live. We're doing it live. This is my... But I have a feeling I know where this is going. Hey, Legal Eagle. Just wanted to come in here and address the issues you raised against me in my video. We started research into our episode on the Fortnite dances November 21st when the 2 milli issues started to really take off, with a V1 draft being finished December 12th. Now, I think maybe Legal Eagle didn't consider what a channel with 11 million subscribers does to prepare a video. I think that's my thoughts on Legal Eagle's oversight here, is that he may have made some misassumptions. So here we go. With the draft being finished December 12th, over a week before your video was posted. Ooh, I have email chains and dated drafts to prove all of this. When I mention, quote, other videos analyzing this case near the end of my video, it's specifically addressing mainstream media's coverage of the event that had gone up around that time. You say our analysis sounds like it came from a real lawyer, and that's because it did. Legal Eagle. He has 11 million subscribers. This is his job. It's beyond a job. It's a business venture. The Game Theorists is a company with resources. I think the assumption that he watched your video and then plagiarized it is hasty. Over the last year, since we've started covering more legal issues in the entertainment space, we've brought on consulting lawyers to help educate us on relevant case law. In general, we have a slate of subject matter experts we consult for episodes like this to ensure we're delivering the best information possible. And we've been covering Fortnite legal issues since June 17th. So us doing another video on a related topic isn't much of a surprise. And yes, while there may be similarities between our videos, it's because we're both stating facts about the law. There's only so many ways to cite a legal document, date of publication, or reference a social dance that's going to be relevant to the most number of people. Disappointing to see that you, as a respected professional in your field, would jump to conclusions based purely off of circumstantial evidence. Telling your audience I ripped off your you video should be your, come on, instead of addressing this to me in a private forum first and asking for my stance. Matt. Now, let me make a supposition. I suppose, or I presuppose, or however you want to say it, I assume, I bet, I wager that that statement was crafted by one of those consulting attorneys. So I'm glad that Game Theorists came in here and clarified this, because that was my thought, was that, and I'll show you why. I'll show you why this was my thought when I first watched the video. I thought, he hasn't even considered the fact that a business venture with 11 million subscribers puts quite a bit of resources into the work that they produce, which is why they have 11 million subscribers. I'm guessing that has something to do with it, that they have a team of or a team that helps produce the content that they make. It's no longer just a guy and a microphone. But let's go on. I'll show you exactly where I think Legal Eagle goes wrong.
To my surprise, Congress relatively recently changed the law to allow you to copyright dances under...
1976 is not relatively recent. Maybe you. Look, oh, every pause is a smug face.
Circumstances. And
It's
as an aside,
unfortunate.
if you ever ask a lawyer anything, you're going to get one of two answers. Either it depends or I'll have to look into that. Legal research is basically what we do. I'll put a link to my original video down below, which will talk about the nuances of copyright and dance,
legal research?
and whether
We all
the
just
various
guess.
artists are going to be able to state a
guess.
claim for copyright infringement based on their dances being used in the video game Fortnite. 8 days after I released my video, MatPat of The Game Theorist released his own video on a similar topic.
Okay. To avoid the appearance of using this entire video, and I'm not going to use this entire video. I want to get to the point where things start going wrong for Legal Eagle, and it's interesting because he calls it out. How many subs does Legal Eagle have? He has like quite a few, 268,000. He acts like a little tiny channel, but he's not. Here we go. I'm going to skip ahead to this part because this is where he...
Copyright Act, he actually quotes from Circular 52, which is a publication put out by the Copyright Office. It's not the law, it's just a helpful guide for lay people.
I should really start
Oh, wait.
Context of a dance or a choreography, who's going to win these lawsuits?
Since dances became copyrightable in 1976, no one has actually made the court define what constitutes a social dance. So the law is a bit overdue on that front.
Okay. How would you know?
Of
Did
course,
you do
not
the
all of MatPat's analysis is correct. For example, in
right?
his video, MatPat doesn't quote from the actual Copyright Act. He actually...
Okay. There. That's where he goes wrong. Sorry, I was goofing around. Let's back it up 5 seconds and...
All of MatPat's analysis is correct. For example, in his video, MatPat doesn't quote...
The law is a bit overdue on that front.
Here we go.
Of course, not all of MatPat's analysis is correct. For example, in his video, MatPat doesn't quote from the actual Copyright Act. He actually quotes from...
Not all of MatPat's analysis is correct. If he plagiarized you... And Smugface again, good lord. I'm not subscribed, Clay, you liar. Don't defame me, Clay. How do I always pause you on a Smugface, buddy? Doesn't make any sense. If not all of his analysis is correct, but he plagiarized your video, how would you have differing analyses? How would that work out if he was just plagiarizing your video? That's where I think it started to fall apart for Legal Eagle, and that he failed to consider that he actually just talked to another attorney and got an opinion that was slightly different than his, and maybe got truncated or shorthand versions like the publication put out by the Copyright Office, for example, that he's talking about, instead of getting in-depth analysis, because he's not a lawyer and that's not very useful to him for a video on Fortnite. Maybe just maybe that's what happened. But how would you know? Did you do the research? Well, no, he paid someone to do it. Oh my goodness. So anyway, I'm not gonna go beyond that. I don't want to sit there and I wouldn't want to be accused of copyright infringement, taking Legal Eagle's content. To be clear, I am ridiculing as well as commenting and criticizing this content, which is protected acts under fair use. And I know that Legal Eagle, as a copyright expert, will recognize that we're well into fair use territory here with his resting smug face. And if he doesn't, he can just clip this out and look at it, tape it to his monitor, and say, my smug face would explain to me why I can't copyright strike this video. So there you go. By the way, Legal Eagle, if you ever want to come on the show and talk, you're welcome to. I just think you made some missteps here. I also, I'm not the biggest fan, but that's okay. That doesn't mean you're a bad guy. It just means I'm not a big fan of your channel. But you could come talk about your real legal work, because I'm guessing it's pretty impressive. You were before the 9th Circuit and all. So, yeah, that'd be cool. That'd be cool. I'm not even trying to sound sarcastic. I think it's just natural for me. So I apologize for that. Anyways, good job, buddy. I'd be interested to see you issue a response to MatPat. Maybe an apology. Would be of wise move, maybe. just a good thing to do. You pinned the response. Did he respond to it? It's only fair that Matt Pat gets to respond, so I'm pinning his comment here. Well, I mean, if it's only fair that he gets to respond, what's your response to his response? What do you have to say about it? Took you long enough but glad you did it. Although it's odd to give a heart to your own comment and not the one you pinned. Oh, ouch. I mean, wow. That's pretty brutal. Goodness gracious. He pinned the comment a bit ago. Yeah, but did he respond? He never responded to the actual comment. All right. All right. I don't know, man. That's yeah. Anyway, let's get that guy's face off there. That's horrifying. Seriously, an apology would be smart. He just lost a sub. Yeah, well, and he maybe should. I don't know. I don't know what he should do. I don't like Legal Eagles content because it's an ad. That's my main thing. His whole show's an ad for his business, but he doesn't. Not his law practice. His how to succeed in law school business, but he doesn't bill it that way. So I don't know. That's it. But whatever. Anyways, guys. Oh God. Million degrees in here. I think now is a good time to wrap up the stream. I don't normally do a Saturday stream. 2 hours is a good length on this one. I really wanted to test out the chat function with StreamMe and Twitch and YouTube all running together. Although I guess maybe this is a violation of Twitch. I don't know about that. I'll have to check into their terms, and if it is, I'll take down the video from Twitch for sure, from the archives, and I won't do it again. It shouldn't be a violation of terms, but if it is, I definitely don't want to rustle anyone's undies over at Twitch. So anyway, thanks for watching, guys. Yeah, chest out the chat function on StreamMe did go to hell. You're right. That's Chessbox. On StreamMe. I don't know why it stopped importing the chat from StreamMe into the video. I don't know what happened. It was in the middle of the video. It just stopped getting the twit or the stuff from StreamMe. I didn't do anything to it. So I apologize for that. It must be some server issue with StreamMe and with Restream. So, but I might find a different way to put all of the chats on stream. I don't know. We'll see. Put on pants. How dare I? Why would I do that? All right, guys. Anyways, let me wrap this up. Thanks for watching. I may stream tomorrow night. May not. Monday night should be the return of Russell Greer, Chapter 7, Why I Sued Taylor Swift. That will be with Sriracha. I'm hoping to have Mark Kern on next week. We're gonna, as soon as I get confirmation from him, we'll be announcing it. So that will be fun. I think he might be a weeb, which based on his Twitter post today, so that would be funny to talk some anime with him, as well as to have him on for, we're gonna have a discussion about the influence of left-leaning values from Silicon Valley being imposed upon its customers. So we'll be talking about that. We'll spend very little time talking about Diablo and World of Warcraft. But yeah, that should be a very interesting discussion. I'm looking forward to it quite a bit. Otherwise, I'll be asking Nick Monroe to come on the show and talk about what he's uncovered on the financial side. But yeah, so all that's coming up. Lots of stuff planned. Really creeping close to that 15,000 subscribers. So if you're not subscribed on YouTube, even if you don't watch it there, please toss me a sub. Just for the numbers' sakes. If you prefer to watch on StreamMe, I of course appreciate that. But yeah, that's what we got. We'll talk to you guys soon. If you have anything else, if you have anything you want me to look at or whatever, feel free to reach out on Twitter. That's where I spend most of my social media time these days because it's very convenient. So, all right, guys, have a nice night. We'll talk to you soon. Peace.